Okay, very good. Well, hello everybody, and welcome to this edition of Macro Pro and Friends. Today we've got a great program for you all, due to audit agonies. And which of us don't want to get rid of some audit agonies? I think that there is a lot of that going on. But I'm joined today by my twin sister and the organizer of EWC. And today we're doing a collaboration with some of the people that tried to, who signed up to be speakers, but unfortunately there were too many topics to choose from, but they're outstanding and we wanted to spotlight them. Deborah, can you tell our audience a little bit about EWC, when it is?
Yes, the EWC is going to take place. First of all, it's the Executives and Workers' Comp and Risk, and it takes place every year, hopefully in April, but it does move around from date to date. This year it's April the 4th, and we are going to be in the Anaheim Marriott Convention Center. And for those of you who are listening, who are participating in this, if you'd like to join us as an attendee, you may do so by going to ewcconference.com. And then when you register as a risk manager or a workers' comp professional, put in the discount code of EWC and you'll get $100 off.
Very nice. That's a very lovely offer that you have made to our audience today. All right, so I just need to do a little bit of housekeeping and then we will turn this over. So today's webinar is worth 1 California CEU credit. You need to be logged on to the GoToWebinar platform. So use the link that was sent to you in order to do that, in order to get your certificate. You will receive your certificate typically within 1 hour of the end of the webinar. And it says my certificate in the email, so you're just going to click that and download your email. If you have a problem with that, please contact your IT department. It's typically a firewall. We do have handouts for today's webinar, so please go ahead and download that now during the presentation. And this program is jam-packed, so there probably will not be time to answer any questions, but if you have any, you can always put them in the chat box and we'll see if we can't get you answers. And then because this information there's just so much of it, we are going to be putting this on the Macro Pro YouTube channel, and you can watch it again for information, inflections, etc. So I am now going to turn this over to Pilar. Pilar is going to introduce all of the good folks that are going to be speaking with her today from Michael Sullivan's firm.
Good afternoon, everybody. For those of you who don't know me, my name is Pilar Mitchell, and I'm a senior partner with Michael Sullivan and Associates. I'm joined here with our internal audit consulting team. I have Sherlog, who is of counsel with our firm and co-writer of Sullivan on Comp. So hopefully you all know the Sullivan on Comp treatise. I also have Cora Lee, who it doesn't sound like you're going to be able to hear from her today, but she's the Director of Audits and Regulatory Compliance with our company. You may already know her. She had a long, esteemed history working with the state's DWC Audit and Enforcement Unit as a supervisor there, and now we're just happy that a manager, I'm sorry. And we're just happy that she joined our team here. It just adds a level of expertise and intimate knowledge with regards to the state's operations that we just didn't previously have. So as you know, just by the topic, today we're going to be talking about audits. The idea is really to give you guys a detailed overview of the different types of audits that are there, the differences between the DWC audits, OSIP audits, and then provide some intimate commentary based on our experience and different trends we're seeing inside of the regulatory audits and how the auditors with both entities really are applying and interpreting the regulations, with the goal of helping you to implement best practices with your company, whether you're a self-insured employer and concerned more with reserves, or you know, a TPA dealing with different types of regulatory benefit audits. So let's see, just briefly, the labor code is what gives the state the authority to even conduct these audits. I won't spend a lot of time on this, but essentially it's found in Labor Code section 129. It gets referenced a lot by the state auditors as giving them you know, authority to go in and audit TPAs. The regulatory audits with the DWC are done every 5 years. If you fail an audit during one of those regulatory audits, they'll come in sooner, within 2 years. They actually call that a target audit, but what they end up doing is just a full audit, just like they would every 5 years. They go from PAR to FCA 1, FCA 2, and we'll touch on that. And then there's types of audits called target audits, also performed by the state, and those are done under also under the labor code, and they're usually premised on things like complaints that are filed, could be a referral from the WCAB if there's, you know, an egregious 5814 situation. Labor Code section 129.5 is what really gives the audit unit, you know, the authority to apply penalties. You guys will have access to these slides, so I don't want to spend too much time on it, but I think everybody understands that the penalties can be pretty significant, especially for things that ultimately become classified as business practice violations. And that's essentially when they see a violation that occurs so often that they believe that you have a business practice that's, you know, essentially unethical, and those can result in civil penalties, which are upwards of $100,000. So they're pretty significant. Likewise, a 5814, if you have a frequency of 5814 penalties, that would also indicate a business practice, and those penalties can be up to $400,000. So pretty significant. So let's get into the types of audits. We're going to start with the regulatory audits, the PAR audit. Sher's going to step in here, and I'm going to provide some commentary along the way. Go ahead.
Thanks, Pilar. So there's the audit that occurs every 5 years, and the routine audit is called the profile. Jesus, excuse me. The routine audit is called the profile audit review, which everybody here probably knows is abbreviated as the PAR audit. And as part of the PAR audit, the audit unit reviews accepted claims in which benefits are paid. And so they'll take a look at a random sample of claims. Typically it's around 58. And then after that, they'll also review files which there's complaints and information regarding a failure to pay indemnity benefits. And so we go through the 5 factors here, but we're gonna go through them in detail. The 5 factors that they look at as part of that PAR audit are accrued and undisputed indemnity benefits, late first payment of TD, or if there's no TD early, then you have to issue a salary continuation notice, late first payment of PD or death benefits, late subsequent indemnity payments, and then the 5th factor typically is called the QME violation, where you didn't send the appropriate notices.
And this is the most, I think this one, sure, when we get to it, is probably the most hotly, right. I don't want to say litigated, but the most contentious area currently, right?
There's the regulations say one thing, and we've seen the audit unit interpret those regulations as being something else, and so we'll certainly get into the details of where there are certain disagreements. Now, what we're going to try to do is tell you what the audit unit looks for. So even though you can raise certain disputes, the goal here isn't to actually file an appeal to, you know, litigate these issues. The goal here is so that you guys know what the audit unit looks for, so that you correct those notices, you correct these practices so that you don't have to go into the appeal, so that you pass PAR. Go ahead, Megan, you can flip the slide. Okay, so for the first factor, what the audit unit will look for is, of those 58 or so files, they're going to look for files where there's undisputed and unpaid TD or PD benefits. And so anytime you don't pay TD or PD when they believe that you should have paid it, they can, you know, issue a notice of comp due. And then where we've typically seen these violations occur are the things that we've got listed on that slide there, where they think you've underestimated the average weekly wage, when you failed to pay TD when due. So again, if you just didn't issue a payment when it should have been due, they're going to find comp due there. The second one, unpaid money during the waiting period. What I've seen a lot of times is, you know, those first 3 days are unpaid unless they're hospitalized or the TD goes for more than 10 days. And so sometimes there's that initial 7 days of TD, they come back to work and you only pay them 4 days, right? If there's a longer period of TD, we've seen these penalties where you don't go back and pick up the TD during that waiting period. So I've seen that happen. Or they'll look and say, hey, you didn't properly calculate the wage loss. This is how much the average weekly earnings were. This is how much they were paid during the period of temporary partial disability. Therefore, you got to go back and pay those TD benefits. The next one, failure to adjust pursuant to 4661.5, the 2-year rule, right? So if TD continues if TD is due more than 2 years after the date of injury, and you're dealing with a max earner or a minimum earner even, then you got to go back, see what the new TD rate is, and then pay at that rate. Failure to pay PD based on the medical evidence. Pilar and I will tell you, we're dealing with a case right now where the adjuster has a PNS report in hand, and for some reason they just failed to pay PD based on that report. And that could be pretty significant because if, let's say, the PNS report issued 2 years ago, and now you've got $10,000, $20,000 in accrued PD, that alone could result in a failing audit. And the other one is failure to pay the self-imposed penalty. So essentially, under 4650D, that's a self-imposed penalty. Anytime you pay PD or TD benefits late, you're supposed to add 10%. The applicant doesn't need to apply for it. You don't need an order. You're just supposed to do it. Now, again, you got the italics there. It does require a claim form. And the audit unit does note, is there a claim form or isn't there a claim form in the file? So if there isn't a claim form, you don't have to add that 10% self-imposed penalty. But if there is, then that is something that you have to do. And again, the last point there, the number of claims with violations and the amount of unpaid indemnity is considered in part of this first factor. So of those 58 factors, how many of those files have accrued and undisputed indemnity? And then what's the total amount due? And so that's what they will use to calculate the score for that first factor. You can have one file with a $20,000 unpaid PD amount that could lead to a failed audit, or you could have 20 files and then they could be $500 each, and all that adds up. So yeah, that's what they look for as part of that first factor. And now you go ahead and skip the slide, Megan. So these are, go back there. So these are some of the practices that, these are some of the things that you should do. And that first point is to document the TD rate, but the truth is you should really document everything you do. Right. Because that's what the audit unit's going to look for. They're going to make sure to say, hey, look, if you didn't pay TD here, why didn't you do it? At least you got to present a reason within the claims notes. If you get a call from the employer saying, hey, the employee came back to work, document that in the file.
This becomes really important because actually the first document that you're getting that's going to create a claim inside of the claim system is the 5020. And that's going to become the default method for calculating the TD rate. They're going to use, and we all know that that's just an estimate that the employer is giving you just so that you can open the claim, right? So it might say $20 an hour, 20 hours a week. The audit, unless you document in your system when you get a wage statement or other information that allows you to adjust the wages, they're going to stick to that 5020 as the basis for how you should, the only information that exists inside of the file for what documents what the average weekly wage is. And we all know people don't work exactly 20 hours a week. I mean, it's possible, but it's unlikely. People have fluctuating wages. And so it could really impact the wage calculation. So you might come up with a different number down the road, but if you don't document that you received a wage statement or you had other information, they're going to go off the 5020. They could find that there's compensation due just based on the fact that your calculation differs from what the 5020 would come to. So this is a really important point.
Right. So I'm just going to go down. We're going to talk about seasonal workers. And one of the things that the audit unit wants you to do to document the start and the end date of the season for those seasonal workers. And they also want you to follow up to determine whether there's off-season earnings, right? So there's the case law that talks about how if you have a seasonal employee, there's two different TD rates, the in-season rate and the off-season rate. Right, so you will calculate how much the employee earned during the season with your employer, but that doesn't mean that you don't have to pay TD in the off-season. You still have to determine whether there are off-season earnings. Now, the case law talks about how if there are no off-season earnings, you don't owe any TD during the off-season. But if there are, seasonal earnings, the case law does also talk about how you have to pay at whatever earnings they had, but at the very least, if there are any off-season earnings, you have to pay at the statutory minimum. The next one, yeah, I mean, this goes for really every file, right? Determine whether there's concurrent employment. If an employee is TTD, then their earnings aren't necessarily, the earnings with the employer that you represent aren't necessarily indicative of what they would have earned, but for the injury. You still have to account for the earnings that they had with any other employer. So whether if they have, a weekend job or a night job and a day job, you have to determine whether there's concurrent employment. Again, this is typically you just ask the employee, hey, do you have another job? And if they say no, your analysis ends. But you have to at least document that you reached out for that information. The next point, consider all earnings, right? One of the easy things to do is just to look for the employee's wages. But let's say they're a forest ranger, or let's say they get a car or some kind of housing. Those things also are considered earnings under the labor code. And so the audit unit's going to expect you to at least account for that. You have to at least account for the value of the, the car, right? The business card that they gave you as part of your salary, or let's say you're given reduced rent, or let's say you're just given full housing. They need you to account for it. Now, let's say the employee still gets to keep the car. Let's say they still get to stay in the house during the period of TD. Do you have to necessarily add it? Well, in that sense, there's no wage loss there. They still get to stay in the house. They still get the company car even while they're TD. So in that situation, I don't think you necessarily need to include it. But if somehow that's taken away, then that should have been included. This is a big one. This is one I see a lot, where the claims administrator will automatically use the last 52 weeks of earnings. What you do need to consider is whether there were any raises within the last year. Because again, temporary disability is designed to replace lost earnings. And so if the employee received a raise within that last year, then it's not necessarily appropriate to average out the earnings over the last 52 weeks. How you do this, there's no science to it, right? There's no exact methodology to it. But what the audit unit needs you to do, and what you need to do, is to at least explain how you accounted for that raise in calculating the average weekly wage. Now, let's say they received that raise 8 months ago. It might be okay for you just to go for those last 8 months rather than the last, 52 weeks. But now let's say they received the raise within the past month. It gets a little trickier, right? Does that 1 month of earnings necessarily reflect what the earnings would have been going forward? What I've seen the audit unit do sometimes is to use their new rate and just multiply it by the hours worked in the previous year. Mm-hmm. Or let's say it's a clear 10% raise. That's a clear 10% raise. What you might want to do is just say, hey, okay, I'm going to include the earnings for the last month, and then for the prior 11 months, I'm just going to multiply that by an extra 10%. Again, there's no exact science to it, but what you do need to do is account for that raise somehow when you calculate the average weekly earnings. And if you do that, then at least you presented a factual or a legal basis. If you don't consider that raise at all, that's when you're going to get in trouble.
Yeah, I think this is, I know I said that the notice violations were a big deal, but I think this is probably the calculation of average weekly wage, and then obviously the resulting compensation due, which is weighed so significantly in the final PAR score, is another biggie that we see. And as Sherlog says, it's not an exact science, and so it's really hard to train on it. A lot of I think a lot of adjusters are trained to take the last 52 weeks of earnings and average it out. And what we're seeing is, while you can document that in your file, the audit unit's really big on trying to understand the person's earning capacity. And so there's different things that they'll do also. Like in the last 52 weeks of earnings, we found that, let's say there's irregular earnings. And sure, you can add some commentary on this too, but if there's irregular earnings and you see some outlier wages in there where they had a couple weeks where maybe they normally earn $800 a week, let's say, and then they have a couple weeks where they've earned 400, right? But the vast majority of time they're earning 800, we've seen the audit unit pull out those wages, right? And
Where we've typically seen it is when they pull out and they have nominal earnings. So let's say they're earning like $900 or $800 a week. Then for some week they go down to $100, $150. Right, we've actually seen the audit unit pull out those weeks. Now, is that appropriate? That becomes a legal issue, right? Because if this is part of their normal cycle, let's say they didn't necessarily, let's say that's part of their normal cycle. They don't work the same hours every single week. There is a legitimate argument to say that we should still include that $150 week or that $50 week.
Because if you think about it, earning capacity includes all earnings, whether you're earning a little bit or a lot. And what we've talked about in the past, it's not like if they have an outlier week where they made a whole bunch of money, that doesn't ever get tossed out, right? So I think obviously the default, we know everybody takes the 52 weeks of earnings and does an average. I think that's a pretty consistently applied method and it's not wrong. But when you see a wages where it fluctuates, and if you see anything that stands out, then you really should trigger something in your mind to do more of an earning capacity assessment and see if perhaps there's something that's really seems like an outlier. As Shir said, you know, at least a couple $100 difference between what they're normally making and what you see in those other weeks, and do the calculation based on that reduced period, pulling those wages out. Now, the safer method probably is to use the higher average weekly wage. But if you are going to choose the 52 weeks, because from our perspective, it is legitimate, it is justified in interpretation of the labor code, document your file, you know, cite the labor code section, explain exactly the 52 weeks of earnings and your calculation, put it into your claim notes, because they're going to be looking at the documentation in the file at the time of the audit.
Right. I've seen plenty of times where the audit unit or the auditor will calculate what they determine to be the average weekly wage, and it ends up less than what the adjuster paid. And obviously in that situation, they're not going to penalize you. So that's the safe thing. Now, was that the most practical thing going forward? Maybe not. It's you know, you're overpaying in certain situations. If there's any doubt, it's obviously safer just to pay a little bit more. But whatever decision you make, the key again is to document why you paid at the rate you paid. Just document that in the file. Because let's be clear here, the audit unit, I mean, this is, I don't know if you disagree, Pilar, but they don't want you to fail these audits. They want you to pass. But they need to know that you considered these factors when you're handling the claims. And so long as you considered it and documented why you paid the way you did, they're going to listen to you. What happens is if you see this and you just don't do anything about it, that's when the problems arise.
Yeah, I agree with that. And I think to the extent you can classify your documentation as either a medical, legal, or factual basis, it's going to clarify also for the auditors what you're relying on, whether it's a fact that you got from the employer, a statute, the 104-week cap, whatever it is. If you could document it in there, it's going to provide a lot of clarity also, and save you from some big compensation due.
Right. So just the last point that we want to talk about on there, scheduled raises, right? This is Grossmont Hospital. Grossmont Hospital talks about how anticipated increases at the time of injury. So you just look at what you knew, what the employer would have known at the time of injury. So if an employee has a regularly scheduled union raise coming up, you got to consider that. If you've seen them get regular raises every single year, you have to consider that. Now, so if there's a union, raise that came after the injury, that doesn't have to be considered. So they are looking for the information at the time of injury. Obviously, as a claims administrator, you're probably not going to know this, but document in your file, hey, ask the employer, is there a scheduled raise at the time of injury? Have they received raises consistently? Just document that you consider that as part of the average weekly wage calculation.
Yeah, one more point, because sure, you had talked about earlier about wage loss. If there's wage loss post-injury, document whether the wage loss is attributed to the injury itself or something else. Maybe the person took PTO, maybe they took vacation. Because if it's not documented in there and they see that the person went back to work but they earned less than they did prior to their injury, the assumption is going to be applied that the wage loss is attributed to the injury itself. And we know that that's not always true. There's a lot of employees that either have fluctuating wages, or let's say that they're just the nature of their employment has certain periods that are just always off. It's seasonal. I don't know. But just if to the extent you can document in there that the person is off because of, it's going to be documented in there if they're off for a medical reason. But often we find that if they're off for a non-medical reason, it's not documented in there. TD's not paid because everybody apparently understands that it's not wage loss due to the injury. But then the auditors come in and it's not documented anywhere, and then they assume it. So that was just one more point that I thought of.
Next slide, Megan.
Yep.
Right. So the second factor, they look at whether you timely issued your first temporary disability payment. So how many claims of those 58 or so have a late first TD payment? Or in a situation where, the employee receives salary continuation, they're going to make sure that you issued a timely notice regarding that salary continuation. And so the basic rule, I'm sure everybody here knows this, is that you have to issue TD within 14 days after knowledge of injury and disability. The regulations are very clear here, though, that knowledge of injury and disability is based on the employer's knowledge. Not necessarily based on when they reported it to you, it's based on when the employer knew about it. And so you kind of have to act pretty quickly when the employer reports a claim to you. And this is where I see a lot of penalties get issued. That last point, that first TD payment has to be paid through the date of the check. I see sometimes where there's we kind of get into this later where so it's that 14th day might be a holiday, right? And so you issue your payment the next day. It doesn't matter. That first check, you have to pay through the date of that first check. Or let's say the mail just didn't go out and it comes late, and now the check goes out late. They're going to issue a penalty if you don't pay TD through the date of that first check. Anything
so what's the fail safe on this? Sure.
I've seen employers or claims administrators overpay. I haven't seen it recently, but I know that there was certainly one claims administrator which would overpay 2 or 3 days just to be safe. Is that something I'd recommend? Not necessarily. What I do recommend is just have a system where when you issue that first TD check, just make sure that all the days are paid up to that first day. Yep. That's all I have for that slide, Megan. Factor 3. So this is, they're looking to see whether you timely paid the first PD benefits or death benefits, right? So again, typically you're required to commence PD from 14 days after the last payment of TD. Normally this isn't an issue when the employee is P&S within 2 years from the date of injury, right? You typically get a P&S report, you stop TD, then you review the report to see if there's any PD. And if there is PD, then you would pay it. Where this might come into play, and I've seen it come into play, is when you stop PD or stop TD based on that 104-week limit. And so the labor code talks about you have to pay PD regardless of whether the extended PD can be determined at that date, and you have to pay until a reasonable estimate of PD has been paid. So let's say the employee is off work for 2 years. You stop TD based on a 104-week limit. You can't just wipe your hands and say, I don't have a P&S report, therefore I'm not going to advance PD. You still have to make a reasonable estimate of what the PD should be. So let's say the employee had surgery within that the past 2 years. Is that something that could be rateable? And this is tricky, right? This is tricky for adjusters who don't necessarily know, who may not be familiar with the AMA guides and what's rateable. We're not asking adjusters to be experts, but we do need them to take a common sense approach and say, look, you have to do something. It makes you, and if you're not going to pay PD because you don't know whether there's rateable PD when you stop TD, document it. Just explain why, hey, look, we don't know if there's rateable PD now. If you look at the last medical report, there's no subjective, or there's no objective findings of disability, and they're simply off work because of pain, subjective pain. That alone might not be rateable. Whatever you do, if you're not going to pay PD when you stop TD, explain why. All right, so the last point, and the audit unit does look at this, right? There's 4650B2, which allows you to defer PD if you offer the employee a position that pays 85% of wages and compensation at the time of injury, or the employee is working in a position that pays 100% of wages and compensation at the time of injury. So that second one probably most likely applies when they're working for someone else. If they're working for someone else and they're earning what they would have earned at the time of injury, yeah, you don't have to advance PD pursuant to the labor code. If they're earning less, you can still make the offer, and the employee can decide whether they want to come back to you or whether they want to come back to whether they want to stay in their current position.
So the last one is basically, sure, what you're saying, when temporary disability terminates because the person has gone back to work, either for the employer they were working for at the time of the injury or a new employer. And so in that situation, permanent disability can be delayed.
Right.
Not because you can't determine the nature and extent of permanent disability. You might have a permanent and stationary report that says 10%
absolutely
PD. But because they continue working and either are earning 85% of their pre-injury wages for the same employer that they're working at, or 100% of their pre-injury wages for a different employer, then you can still delay PD on those grounds. I don't think a lot of people know that.
Right. So this is regardless of, like, even if you know what PD is, you're right. 4650B2 still allows you to defer PD.
Mm-hmm.
You just have to make that offer of work of 85% of wages and compensation. Once you make that offer, if the employee declines it, you still don't have to advance PD, but we'll get into the next slide. You still have to go back once there was ultimately an award. All right, go back to the next slide, Megan.
Just really quick also, sorry, sure.
Okay.
I think, wasn't there something also that if the person has lost no time from work, then they're presumed to have been made an offer. So if you have someone that never went out on temporary disability, they've always continued working, but you get an MMI report that says 5% permanent disability, but let's say your employer didn't make an offer of work or didn't do anything specifically, it's presumed that they've continued working and you could still delay PD, right?
Right. And so that one's tricky to apply. And the reason I don't bring that up is, so you have to have gone back to the same position and lost no time from work. So, right, so they've lost even just a couple days of work, and then they go back to their regular duty, and now they're P&S. That regulation doesn't apply anymore.
Right.
And so it has to be someone that they got injured, they're still working their full time, never got any TD, and now they're P&S. Then right, they're presumed to have been offered the work. But it applies in that very narrow situation where there's no TD, and so it's.
What if they go? What if they go to a better job? Sure. Well, what if they go to a job that's paying them more? Do you know how that would?
Job that's paying them more. I don't remember.
Not to put you on the spot.
I honestly don't remember. Like, I didn't know, but I thought it had to be the same job.
Yeah, you're probably right. That makes sense,
so
because then it shows
shaking your head that it has to be the same job.
yeah, then it shows that the injury didn't affect
Right.
your wages, period.
So
Okay.
again, that regulation comes with a bunch of little caveats, and so that's why I didn't want to bring it up for the purposes of this webinar.
Yeah, understood. Moving on.
All right, so now we're on the best practices. Monitor for P&S reports. We're dealing with a file right now where the claims administrator, got a work status report releasing the employee to full duty, and then they just close their file. And then, this P&S report comes in and they didn't monitor that. That can result in, the failure to pay PD, right? And right, so just this next point is also important. Just because there's a WPI in the report, you don't necessarily have to pay it, but you're going to have to document the reason you didn't pay PD. So let's say you get a report from a PTP, they reported 3% WPI based on pain or whatever, but it's not consistent with the report itself, or the report is inconsistent. Explain that you're not paying PD even though it's reported. Or let's say you get a QME report versus a PTP report. What the audit unit does look for is that you explain why you relied on that earlier PTP report that had 0% PD versus the QME report, which might report like a 3% WPI or something like that. Now, are their practices always the best? No, but if you document why you're not going to pick up PD based on the QME report later, it's going to allow you to say, hey, look, this is why we didn't pay. And that's what they're really looking for.
Mm-hmm. Yeah, it all goes back to documentation in the file, because what they really don't like is when you get into the audit and you start coming up with amazing rebuttals, which I'm sure we can often do, right? But if it wasn't documented in the file at the time that the adjuster made whatever decision they made at the time, then the auditor's position is, I mean, very good argument that you're coming up with now on rebuttal, but that's not what the adjuster, or at least they didn't document that that's the reason that they made that decision. And so a lot of times that can become an uphill battle, because like we said at the beginning, the goal is not to have to file an appeal. The goal is to engage in the informal back and forth process with the auditors, explain why decisions were made, and hopefully get some of their findings taken off or reduced so that you don't fail par. That's the goal. And having documentation in the file is the best way to be able to do that.
Right, and so this next point, yeah, look, you have to pay PD to the last date of TD. So let's say the employee, you pay TD benefits, and then you get a P&S report. You still got to go back to that last day. That's how the labor code is written. You don't necessarily go from the P&S report. You go back to the last payment of TD. And this is, again, so this goes to that last point as well. So we talked about 146.50. If it was a B2, you can make an offer of work and then defer PD, right? But now once you get an award, you still got to go back to the last date of TD or the P&S date, whichever is earlier. So making an offer of work doesn't allow you to avoid payment of PD benefits. It simply allows you to defer it till a later time in which you're certain now this is what the PD is going to be. Anything else to add on that, Pilar? Otherwise, we're ready to move on.
Let's move along. It's
right. Yeah.
Some stuff to get
so
through.
Factor 4. So for this factor, they look at, again, we've talked about the first TD payment, the first PD payment. This fourth factor looks at the number of violations for late subsequent indemnity payments. So any payment after that first PD or TD payment, anytime you pay that late, they're going to consider that a violation, right? So as a general rule, you pay on a 14-week cycle. There is this regulation though, 10108A, which says that the payment is due on a holiday. The payment may be made the last business day before or after the first business day after the holiday. So again, if there's a holiday, you can pay before or the first business day after the holiday. That doesn't change that 14-week cycle, that 14-day cycle. but that's just something to be considered as well. And so for this one, you can have multiple factor 4 violations, right? You can have a file where the claims administrator paid TD late 5 times, 6 times. For the purposes of calculating the PAR score, it still only counts as one file with a violation. So just as a matter of strategy, if you're trying to decide which files you want to challenge as being a factor 4 violation, you probably want to limit it to the ones where you only have one late subsequent indemnity payment. Otherwise, you're going to have to prove that every late subsequent indemnity payment was timely or that you acted properly for each one. All right, next one, Megan. Factor 5. This is one of the most controversial, if you will, factors that they look at, and this is one where we see a lot of disputes. Pilar can confirm this, but you know, after the 2016 regulations came out and there became new notice regulations, the number of failed PAR audits and the number of failed audits generally went up because of how the audit unit interpreted these regulations. So I just put the language in here just so we could see what they're talking about. So factor 5 looks at failure to comply with the requirements for notices advising injured employees of the process for selecting AMEs and or QMEs, or for injured workers with injuries on or after 1104, the failure to comply with notices advising of them of the voucher, right? So if you look at that regulation itself, it talks about the failure to comply with the notices advising employees of the process for selecting AMEs or QMEs. What we've actually seen is how the audit unit interprets that is they will review to see whether you issued TD or PD notices. And if you don't issue proper TD or PD notices, they're going to find that to be a factor 5 violation. Now, we do have issues here because they will still find a violation of factor 5 after the employee's been evaluated by a QME. Right?
Right.
And the argument then becomes, how does that become a failure to advise them of the process for selecting a QME when one has already been selected? Again,
not just that, they're also, sorry, sure, I didn't mean to cut you off, but they're also interpreting essentially any defect in those notices as a QME violation. So if you didn't attach a medical report, this is one of the big ones, right? Sure. Like a failure to attach
we'll talk about the medical report later.
We will? Okay. I won't get into it then. But let's just say that they're interpreting any defect in the notice to essentially also not just be a defect, but it's almost all of them are being interpreted as material defects, and therefore it impacts the injured worker's ability to understand the QME process, and therefore it's a violation of the QME process. It's very.
So the regulations themselves only allow the audit unit to issue a penalty for a material defect in these, notices, right? TD or PD notices. But essentially, they're finding that any defect that isn't consistent with the regulations themselves is material. Is it intended that way? We don't know. That's obviously a legal issue, but that's how the audit unit is applying that regulation. So again, this is one where you can have multiple violations of this 5th factor, but each one only counts as one violation for the purposes of the PAR score. So again, if you're going to challenge this, you're going to look at the ones where there's only one violation, or where you can at least challenge their finding regarding the multiple violations for that file. All right, go ahead, Megan.
But to that point, sure, the TPAs usually have a process in place for the notices and how they're operating. So the reason it becomes a big impact on the score is because it's repeated over case over case over case over case, because you're issuing notices on every single case 5, 6, 7, 8 times. Every time you're doing it, you have a set process in place. You're doing it wrong every single time. There's different violations. They add up case over case over case.
Right. So this one, there's 2 big notice regulations, 9810, and again, the next one we'll talk 9812. the big thing I want to talk about here is there is a benefits notice instruction manual. And so the regulations talk about how if you use those sample notices, then your notices are presumed to be adequate. What we've actually seen the audit unit do is if you don't comply with that manual, they're going to find a violation. Now, is that proper? We don't necessarily think it is, so long as you are acting in accordance with the regulations. The regulations do not require you to use the benefits notice instruction manual, but again, the goal here is to make sure you guys pass par. And so, yes, just please make sure you're using that your notices comply with the benefits notice instruction manual, so there won't be any issues.
Yep.
All right, next slide. So 9812 is the more detailed regulation which specifies all the notices that you have to issue. And I put them all here, but typically it's done on a 14-day cycle, right? 14 days after TD denial, 14 days after determination to deny. When you make a decision to terminate benefits, you have to send it at the time of the decision to terminate, or if it was made after within 14 days after the last payment. So again, this slide's just simply to advise everybody that there's a 14-day cycle for most of these notices. Next one, Megan. All right, so this is one of the issues that Pilar was trying to bring up, right? There's the fifth factor relates to the QME AME process. And the regulations themselves state, if the claims administrator's determination is based on a medical report, a copy of the medical report shall be provided with the notice except for psychiatric reports that the psychiatrist has recommended not be provided to the employee. What we've seen the audit unit do, they essentially require you to attach the last medical report with every TD or PD termination notice. And it becomes a legal issue, right? Because the regulations themselves talk about how it's if your determination is based on the medical report, then you have to attach the report. That's the condition, but they're requiring you to attach that PTP report to all of them. So all your NPD and NTD notices. So just do it. Like, don't just do it. Whether we agree with their application or not, that is how they're applying that regulation. Oh, and another thing. So when you issue these benefit notices, you're supposed to attach URL links to the chapters in which the benefits pertain. What the audit unit asks you to do is essentially to attach a link to chapter 4, which relates to resolving medical care and medical reports. They want essentially all TD and PD notices to include that link to chapter 4. Is it appropriate? Is it actually required by the regulations themselves? That's an issue. We fought with them over that issue. But for your purposes, just make sure that link to chapter 4 is in there. If you look at the sample notices in that benefits notice instructional manual, they're going to tell you what links you need to attach to each notice. Just follow that. Right. I'm going to go a little bit faster because we're running out of time. So, yeah. Right, we look at those 5 factors, and if you're in the worst 20%, then you fail, and then you got to go to the FCA 1. Now, if you pass, and because the goal is to pass, you don't have to pay any administrative penalties. So they can find all these violations, but if you pass par, you don't actually pay any penalties related to that. You do have to pay indemnity due to the employee. So if they say, hey, you owe this much money, and they're going to provide a list of what they call comp due files. You have to pay these employees. You got to still pay the employee, but you don't necessarily have to. You don't have to pay any administrative penalties if you pass par. If you fail, you go to FCA 1. All right, next slide, Megan. In the FCA 1, again, you failed par now. They're going to review additional indemnity claims. They're also going to review complaints. And then again, so now they're looking, if you're at the bottom 10%, you fail, and then they go to the FCA 2. If you pass the FCA 1, you have to pay all indemnity due, and you have to pay penalties related to, late or unpaid compensation. So there's still a limitation on the penalties that you pay. but you still have to pay the injured employee. All right, Megan, next slide. All right, so now we're in FCA 2, right? So now they look at all claims for all violations, and they also review denied claims. And they're also going to review complaints as well. So now, at the end of the FCA 2, they're going to issue penalties for all the violations. And this is where they start to add up, because now they're going to issue penalties for failure to pay medical bills. And then, so you got to pay all those penalties, and there's a multiplier, right? So just because they're looking at those 58 claims, if you're a bigger TPA, that multiplier can be more than double. I forget the exact math, but again, it's based on the size of your claim. So they're auditing a sample of your claims, and then the ultimate penalty is based on the totality of the claims that you have. So the bigger you are, the bigger that penalty, the bigger the multiplier. Right, you still have to pay an indemnity due to the injured worker. And then there's another audit in 2 years. As Pilar mentioned, they call it a target audit, but it's really, they restart this entire process where they start with PAR, FCA 1 and FCA 2. And the other thing I need to mention here, you do not want to fail 2 audits, because the regulations talk about how if you fail 2 audits, you have to be referred to the insurance commissioner who reviews your license to administer. So it's a big deal. We've worked with the audit units. We've negotiated settlements with them. Again, they want you to pass. So at the end of the audit, you typically have a conference. And as part of that conference, you can typically reach an agreement where they will only audit files after the end of the audit. So they're not going to, so if you've identified any shortcomings in your claims practices, they want you to fix it. And a lot of times you can reach an agreement with them where they will only audit files now after after the audit finishes. So that you've now seen what you've done, you've had a chance to correct it. Anything else you want to add, Pilar? Otherwise, we can keep going.
No, let's keep moving along.
All right, let's keep going. Right, they issue the report. Then there's 2 different processes, right? They're going to issue notice of penalty assessments and notices of compensation due. And there's 2 separate appeals processes. One is an appeal of the comp due, which goes to the individual worker. So they're going to issue their audit report, and they're going to find such and such employees are owed a certain amount of money. Any of those comp due findings that you want to appeal, you have to appeal at the WCAB level, and you have to file a DOR at the same time as you file your appeal. Any notice of penalty assessments is heard by the administrative director or designee. Now, George Perisotto typically doesn't conduct these. He normally assigns a WCJ to conduct the review of the notice of penalty assessments. All right.
Yeah, it says that he can assign a designee, but we've always seen it be a WCJ.
He's never done it himself, and I'm guessing he probably won't.
Yeah.
All right. Go ahead, Pilar. Didn't leave you much time.
Uh-oh. OSIP. So OSIP stands for the Office of Self-Insured Plans, and it's essentially oversees self-insured employers. There's different type of audits. There's the regulatory audit. They're on a 3-year cycle. And then OSIP also has target audits or special audits, so they can come in for good cause and do a specialized type of audit. We can go on to the next one. The major oh, I'm sorry, I don't have this slide. So sure, help me out with this one.
So here's the thing. Cora put in this slide. Cora was supposed to talk about the OSIP issues, and she put in this slide this morning, and it's going to identify the 10 things that OSIP looks at.
Okay.
And so they're all listed here. And the truth is, I haven't gone over them because it was thrown in this morning.
Well, the good thing is that everyone's going to have access to these slides. They could read through it. If anyone has questions about these 10 most common issues identified by OSIP, just feel free to reach out to us and we can provide more context and insight on it. But really the main purpose of the regulatory audits for OSIP is to really make sure that these self-insured employers, which have been deemed, solvent enough and ethical enough, let's say, to be insuring their own claims, that they're engaging in proper reserving practices. So next slide, Megan. So really, reserves is a big thing that we all talk about all the time. And the reason is that you know, you have to set aside a certain amount of money on the claims to make sure that it's going to be covered. And so to understand what
so the main point, if you guys don't take away anything else from this, they want you to set a realistic estimate, right? They don't want you to under reserve things. And then the other point, and I don't know what's mentioned here, is you as the claims administrator are responsible for setting that reserve.
Right.
OSIP does not want the employers to manipulate you. They don't want the employer to have influence over the reserves you set.
Right. It's
So
kind of
as
a
a
checks
claims
and balances.
administrator, it's your job to set that reserve.
It makes sense. It's a checks and balances. They don't want the where the money's coming from for those people to be making determinations about how much should be set aside for a particular claim, because the interests diverge, right? The TPA is there to make sure that there's money to cover the claim, but an employer might want to set aside as little amount of money as possible, right? Because it ties up money that could otherwise be used for other things. So yeah, I think sure that's a really good point. Because I know that we're running tight on time. If there's anything really to take away from this part of it, is that you have to set a realistic estimate. Obviously, that's kind of a term of art. It's not as easy to assess as you might think. You have to be estimating anytime you get information that you think would require you to adjust the reserves, like an updated medical report, in order for the appeals court, or other relevant information. At the very least, updating reserves once a year, and that's just at the very least.
Well, so that goes to the next slide, that point that you mentioned, that they're required to adjust reserves upon receipt of relevant information, right? Medical reports, orders, anything that would affect the reserves, you have to change it. So, you know, if you get the employees has surgery now. I wish I could hear you, Corey. I know you got something brilliant to say.
Right.
So yeah,
the benefits that are included when we're calculating reserves are, there's an indemnity. So that's temporary disability, permanent disability, the death benefits, and then the voucher. And then there is the medicals. So when we're talking about permanent disability reserves, something that comes up a lot is, and this goes back to the original definition of estimation.
Next slide.
You might have competing medical reports with regards to PD ratings. And so the estimate that you come up with has to be based on the higher calculation for permanent disability, not on the fact that you could argue for the lower one. So if you have a PTP report that rates to, let's say, 20% PD, and you're like, this person has a cut on finger, and then you have a QME that's 0%, your reserves have to be at the higher percentage, unless you can document very specifically why that medical report shouldn't be relied on. So you can't just say, I have a feeling that a cut on a finger can't be 20% permanent disability, so I just don't like this doctor's opinion. Even though a lot of us might understand that, you have to document specifically why that medical report's not substantial medical evidence, and why you shouldn't have to reserve up to that number. Another thing to consider, sorry, just really quick, sure, with regards to
the next slide, you can cut to it.
Yeah, Megan, if you can go to the next slide.
Because this is, yeah.
Sorry, we're just tight on time, and I don't want to
talk about here, that you got to reserve on the whole report.
I want to get to the most important points. For rating, or when you're talking about the anticipated liability, I know when we do, let's say you have a case and you do an MSA, they might use a rated age. You can't use the rated age for reserves purposes. You can use it for the MSA. You might be able to use it for other things to come up with your settlement negotiation number for the CNR, because you think that so-and-so is going to live less because you did a rated age. There is a national age expectancy table, and they go off of those numbers. So when you are calculating reserves, again, if you have an MSA that has a rated age, you can't use that for purposes of reserves. And then again, the estimate of PD can't be reduced by apportionment unless there's documentation in the file supporting that there's apportionment. So that would be, I think, and what I've argued is if you have a lot of subpoenaed records which show that this person with a shoulder injury actually had 10 years of prior shoulder surgeries, whatever it is, that would be documentation in the file that would support the conclusions of apportionment. But if it's just you only have a QME report, I mean, sure, correct me if I'm wrong, but what I found is that all you have is one medical report where the doctor just apportions to pre-existing condition or degenerative condition. We can argue that that's documentation in the file that supports apportionment. I've gotten pushback before from OSIP on that, where they
the
say
language
that
is vague, right? So it says that unless there's documentation. What is sufficient documentation?
That's the question.
Yeah, that ultimately becomes a question. Whatever you do, explain why you've taken apportionment. This document or this document supports it. You just have to explain why you did what you did with the evidence that you have.
Agreed. Okay, so estimating future medical reserves when the employee is not permanent and stationary. This is a little bit more difficult because obviously if you have a P&S report, there's usually a paragraph inside the P&S report which provides provisions of future medical care, and then it kind of outlines what's anticipated. You could price that out. It's a little bit easier. So you kind of have to do your best. I guess kind of put your doctor hat on a little bit, decide whether you think it's a minor injury or a serious injury, how much time you think it's going to be to get the person to MMI. It might become an important new practice point for you to be pushing back on the treaters and asking how long until this person is going to be permanent and stationary, and what treatment do I need in order to get that person there. That's going to help inform your reserves. Otherwise, if I'm being honest, and sure, correct me if I'm wrong, it is a little bit of a best guess situation.
It is a best guess, and I know that we push back with OSIP sometimes saying, hey, look, I've seen them ask an employer to reserve for a contusion. I'm like, dude, do you know what a contusion is? It's a bruise. And then when you kind of present it like, okay, we're not going to ask you to reserve. So OSIP will take into account, whatever arguments you make. But again, it's best if you document why you made the decision you did.
Right. And then you have the situation, the next slide is when the employee is permanent and stationary. Like I said, this becomes a little bit easier. So let's see, the CCNRs indicate that if the employee's injury is permanent and stationary, then the estimate has to be based on an average annual cost over the last 3 years. Or a lesser period if 3 years has not passed, projected over the life expectancy. Again, life expectancy there means the life expectancy national tables, not a rated age that you got from a MSA vendor.
Right. And so the next slide does talk about what you've already been talking about, Pilar, that no reduction for. Oh no, there's a slide thrown in there. I guess there is. But if we go to the next slide, Megan, there's no, keep going. There's no reduction for life expectancy at present value. So that's what Pilar's been talking about this whole time. Yeah, we're at time, so.
Sorry to do that last part so quickly, but we sincerely hope that you enjoyed this presentation and that we provided you a little bit of insight as to what we've been seeing representing various TPAs and self-insured employers through the audit process. If you guys have any additional questions, please feel free to reach out to us. Our emails are here. Email any of us. We'd be happy to answer questions, or if you need help on your next audit or prepping for an audit, just let us know.
I see that there are several people who typed in questions. So if you would jot those emails down and give the questions directly to them, that would be fantastic, so you can have your questions answered. And thank you very much for being willing to do that. This was a jam-packed webinar with lots of information. So just want to thank you for participating today. You guys did a fabulous job, Michael Sullivan and Associates. Cora, sorry that you had computer issues. Deborah, do you have anything else you'd like to say before I have a few last announcements myself?
Well, come on by to the EWC. You will see Michael Sullivan and Associates group there as well. And for everybody who is part of this webinar, you guys can type in EWC as a discount code on our website. You'll receive $100 off. The website address is www.ewcconference.com. We look forward to having you guys join us, and we thank you guys for participating. And I don't get to say this very often, so forgive me, but my sister does such a phenomenal job with this. And I know you guys cannot be seen, but hands up to Diane, because she is so amazing at what she does and keeping the industry educated. And thank you, Diane, for all that you've done.
Well, you're quite welcome. There's nothing like a twin sister gloating all over you. Thank you. So I just want to remind everybody that MacroPro has in-person conferences as well. And so on April 25th, we're going to have one in Rancho Cordova. So if you're in the greater Sacramento area, check our website out. There'll be one there. Also in the East Bay on May 1st and in Ontario on May 8th. So we have 6 hours of CEUs. The entire day is free to claims handlers, so we certainly hope that you can join us. Again, you can watch this performance on the YouTube channel from MacroPro. Until the next time, bye-bye now.
Thank you. Thank you for having us.
Bye-bye.